To your knowledge, has DOJ released all the special counsel's files, either to Congress or to the public?
I don't know what they've released to Congress.
Do you believe it's in the public's best interest to view the full case file rather than just selective samples as they've come out so far?
The reason I'm pausing is I'm not sure it's proper for me to weigh in on that. I don't know if there are, for example, confidential information regarding witnesses that shouldn't be made public. And so I think that's a matter for others besides me who have the case files in their possession now to review and decide.
So let's just narrow it a little bit. Do you think it would be beneficial for the committee to review the case files so we can understand why certain investigative steps were taken?
I'm going to leave that to others to decide. I'm here and I'm happy to answer any questions you or anybody else might have.
If the case files were released, would they include any political considerations by you or your team as you investigated and charged these cases?
We did not consider politics. I did not consider politics, anyone's politics in charging these cases.
And that would be borne out, presumably, by the case files?
I'm not aware of anything in the case files that would contradict that.
Because it never happened.
It never happened.
I also just want to note the authorization that you got from DOJ, and I think this is marked as Exhibit 2. No, sorry, Exhibit 3 by the majority. It was quite broad, right?
Which one is this now?
This is Exhibit 3, a letter from the Department of Justice to your counsel.
I have my own copy. Apologize, we've got a lot of letters here, so.
Take your time.
Just don't have a lot of evidence
Here you go.
that's been disclosed.
Okay, I have the letter now,
Okay,
yes.
so I'm looking at page 3 on the bottom, but this letter essentially walks through a series of topics that you are authorized by the DOJ to discuss.
Correct.
Okay. So on the bottom of page 3, I'm reading here from the letter. The extraordinary events underlying this matter constitute exceptional circumstances warranting an extraordinary accommodation to Congress in this particular case. Given these extraordinary circumstances, to the greatest extent allowable by law, the department authorizes Mr. Smith to provide unrestricted testimony to the committee, irrespective of potential privilege, including the names of line attorneys and agents in the department as it pertains to the matter identified in this letter, and as limited in paragraph 1 through 5. And the paragraph 1 through 5 essentially goes through the investigations that you undertook and I guess a couple of tangential matters related to the Office of Professional Responsibility and the Arctic Frost investigation. Is that correct?
That's what that says, yes.
Okay. So given that DOJ gave you unrestricted or authorization to provide unrestricted testimony, would it make sense that DOJ then should also give this committee unrestricted access to the case files that's currently in its possession?
I'll leave it to others to decide that. I will say that the paragraph you read is different than it's been with past special counsel. Past special counsel usually testify about the contours of their report. They've changed the process here, and I'm still here willing to answer questions.
Okay, thank you.
We're gonna, I believe we're on Exhibit 10 now. We're gonna move on to Exhibit 10, which will be your Special Counsel Report, Volume 1, dated January 7th of 2025. I know this is a document. I know this is a document you're very familiar with, but we'll pass it around. So as the date of your report says, on January 7th of 2025, and as your time as special counsel was coming to an end, You provided a final report to the Attorney General where you explained the prosecution and declination decisions that you made as special counsel as required by 28 CFR 600.8. Is that correct, sir?
That's correct.
What was your goal in preparing this report?
I wanted to, at first, make sure I fulfilled the obligation under the special counsel regulations to do a report consistent with the regulations.
And was this final report an accurate account of your investigation and its findings?
It was.
Based upon your understanding, is it generally the practice for a special counsel's report to be made public to the American people?
I believe so. I know at times they've been, portions have been redacted in the past, but my general understanding is yes.
So to the best of your knowledge, do you recall Special Counsel Mueller's report being made public?
It was public, yes.
To the best of your recollection, do you recall Special Counsel Herr's report being made public?
Yes.
To the best of your knowledge, do you recall Special Counsel Weiss's report being made public?
I don't recall. It may be, I don't know.
Was your report made public in full?
This report as to the elections case, I believe it was made public.
Did you have a separate volume or a volume 2 of your report?
That's correct.
Was that made public?
No.
Touching on volume 2, in your letter to the Attorney General, you also recommended that volume 2 of this report, which discusses the classified documents case, not be publicly released while the cases of Mr. Walt Nauta and Mr. Carlos de Oliveira remain pending. Do you recall saying that in your letter to the Attorney General?
That's what's in the letter, yes.
Can you explain, please explain why you included that recommendation?
When, as special counsel, when you draft a report like this, it's not for me to decide whether it gets made public or not. It's for the Attorney General, and it's for him to also to decide what portions, if any, get redacted in that. And so what I stated was my, in essence, recommendation that it should not be public because these cases are pending and there are facts in here that it might not be fair to have that be public while they have charges pending against them.
Understood. So other than the fact that the cases of Mr. Nauta and Mr. Oliveira were still pending, as you just discussed, did you have any other reasons to believe or to recommend that volume 2 of the report should not be publicly released?
Well, again, that wasn't my choice. My choice was to write a report for the Attorney General to make a decision about whether it would be public. I have no objection to it being public, and I didn't then, as long as it complies with the law in terms of 6C and other issues like that.
If we're just going back to that recommendation, in making the recommendation in the letter that it not be made public, understanding that it's the AG's decision to release the report, did you have any other reasons for making that recommendation other than the ongoing cases of Mr. Nauta and Mr. Oliveira?
I'm sorry, I misunderstood your question. No reason other than that.
Is there any other reason right now, since Mr. Nauta and Mr. Oliveira's cases are no longer pending, is there any reason now that you can think of, other than Judge Cannon's order, where volume 2 of the report should not be released?
Judge Cannon's order is the reason.
Excuse me, can I jump in? Do you know who was responsible? Did you dismiss the Nauta and Oliveira cases?
No.
Do you know who dismissed them?
I don't recall, but I imagine it's a matter of public record.
If I told you that it was after Donald Trump was inaugurated, would you agree with that?
I don't recall, but if that may well be true.
For the purpose of this remaining conversation, since that's a publicly identifiable fact, I will represent to you that it was done by the Trump administration. You charged that case, correct?
Correct.
You went through your extensive experience as a prosecutor. Do you believe that Mr. Nauta and Mr. Oliveira were guilty of the crimes that they were charged with?
Yes, we believed that we had proof beyond a reasonable doubt for all the charges and that we would have gotten convictions at trial, yes.
And are you aware of any reason within the rules, protocols, and regulations of the Department of Justice that case should have been dismissed?
In my view, no, it shouldn't have been.
Real quickly, before I turn over to Mr. Jayapal, are you able to speak about Volume 2 today?
I'm not.
Can you explain what you can and cannot speak about with respect to Volume 2?
Well, there is an order of Judge Cannon, an injunction regarding Volume 2. I want to make very clear that I do not want to do anything to violate that injunction or that order. And so, given that I have not seen or looked at Volume 2 since I submitted it to the Attorney General almost a year ago, I do not have a exact recollection of what is in there and not. And so, unless something is in a public filing, or, and people can point me to a public filing, or in, I think the category that was mentioned in the letter that we got this morning of publicly, I can't remember the terminology, but properly publicly released information, I do not want to, I want to be clear, I do not want to violate that order, and I don't want to do anything that could even be remotely construed as violating that order.
Wait, so, I'm sorry, but DOJ did not let you review Volume 2 of your report?
It may well have been there, but I chose not to review it because I didn't want any implication whatsoever that I was somehow violating the order by looking at it, not being a member of the department now.
So before we go to Ms. Jayapal, I just want to clear up two things. One, so you've been an assistant DA, you've been a federal prosecutor, you were an international criminal court prosecutor, you were the chief of the public integrity section at DOJ, and you were first assistant U.S. attorney in Nashville and the acting U.S. attorney. Do you have any idea how many cases you've actually handled and prosecuted?
That I've handled or supervised others handling, I'm sure it's in the thousands.
In the thousands, okay. Have you ever been prosecuted for selective prosecution, vindictive prosecution, or partisan discrimination?
Never.
Have you ever fired a prosecutor because they refused to engage in a prosecution on grounds that there was not sufficient evidence?
No.
Okay. And in all of the cases that you have supervised and prosecuted yourself directly relating to domestic violence, relating to conspiracy, relating to murder, relating to war crimes, have you encountered the problem of witness intimidation?
Very much so.
Will you speak a bit about the problem of witness intimidation and what that does to the rule of law and justice?
Witness intimidation is probably the most corrosive thing that can happen to the rule of law. And that is why, as a young prosecutor, you are taught to move your cases expeditiously, because you know that if there is someone trying to obstruct your case, the longer they have to do that, the more they can subvert justice. And I've worked on a number of cases. I've worked on murder cases where witnesses were murdered. I've worked on cases overseas involving very serious witness intimidation and obstruction of justice. And as I mentioned earlier, this case as well. And so that was foremost in my mind as we were conducting these investigations, but it's something I've encountered in different contexts throughout my career, even back to those domestic violence cases that I started in earlier in my career. Attempts to threaten or influence those witnesses are a way to subvert justice.
So what kinds of actions and precautions can you take as a prosecutor to prevent it and to try to protect witnesses against intimidation and violence?
So depending on the situation, there would be different sorts of steps that you could take. Obviously, if it's an imminent threat, like someone's coming to kill the witness today, you try to move them and protect them for a period of time. But if it's a more pervasive threat, where a defendant or people on his behalf are issuing statements and issuing threats, trying to get people not to cooperate with your case, or trying to make an example of people who have cooperated with your case, the best thing you can do is limit their ability to make those threats and shorten the time they have to make those threats.
Thank you. Let me go to Ms. Jayapal.
Can I just, one thing on Volume 2 before we go? It's obviously a case related to classified documents. without getting into the detail, how was it how was it written? Was there an unclassified portion and a classified portion, or is the classified material interwoven in the volume?
I don't think I should even talk about that. I don't want to have any implication that I gave some sort of insight about how that report is constructed. And so I don't really think I could speak about that given her order.
Can I ask you this question? Is it possible to release parts of that report while also protecting classified material?
I very much want to answer your question, but I don't want to say anything that will imply what is in the report, and so unfortunately, I don't think I can answer.
Okay,
This is-
again, I'm going to go to Ms. Jayapal. We'll come back to you. Yeah.
Thank you. Mr. Smith, I want to get to questions of transparency again, but I want to pull out to a bigger question. Do you think that it's important for our democracy to hold free and fair elections without interference or obstruction?
Yes.
And theoretically, what happens if there is election interference and the people who are responsible for that are not held accountable?
It becomes the new norm, and that becomes how we conduct elections.
And so the toll on our democracy, if you had to describe that, what would that be?
Catastrophic.
You stated in your testimony in the first hour that you've tried to be as transparent as possible with the American people about your investigation. The chairman of the committee has repeatedly put out that you were subpoenaed for your testimony today, and in fact you are here under a subpoena, but you had requested to appear voluntarily in a public hearing. Is that correct?
Yes.
And why were you willing to appear voluntarily in a public hearing?
We conducted our investigation in a way that I'm proud of. I'm particularly proud of the people I conducted the investigation with, and I wanted to speak for them.